Hello and welcome to the Emerging Litigation Podcast. I'm your host, Tom Hagy. So healthcare marketing is undergoing a rapid transformation. Traditional advertising channels are giving way to digital-first strategies built around social media, online testimonials, influencer partnerships, influencers for those, like me, and user-generated content also like me. For healthcare organizations, and this is pretty new, but well, I don't know. It's been expanded. Let's just say it's been accelerated, like a lot of things you've always had, patient testimonials and pamphlets and things like that. But anyway, this shift offers new opportunities to build trust and visibility for healthcare organizations, but it also introduces, otherwise we wouldn't be here, serious compliance risks, and this time under HIPAA. A recent enforcement action by the U.S. Department of Health and Human Services Office for Civil Rights against Cadia Healthcare facilities puts those risks into sharp focus. And we're going to use that as the jump-off point for our conversation today. I'm happy to be joined by Liz Heddleston and Leah Stiegler. They are principals at Woods Rogers. They're experienced advisors to healthcare organizations on HIPAA compliance, privacy, and regulatory risk. The practice focuses on helping providers, business associates, and healthcare adjacent organizations navigate privacy obligations in increasingly complex digital and operational environments that they're in. I think we're all in those. Liz and Leah regularly counsel clients on HIPAA enforcement actions, breach response and enforcement training, compliance challenges that arise at the intersection of healthcare, marketing, and technology. They are frequent writers and speakers. What do you think? We have schlubs on the Emerging Litigation Podcast on emerging healthcare privacy issues. I just adjusted myself in my seat. My wife tells me not to do that, including digital marketing practices, social media risk, and evolving OCR enforcement priorities. Leo is also a repeat guest, I'm proud to say. Don't know why she came back, but she did. And she makes talking about law fun, frankly. If I were smart enough at a certain age, I would have liked someone like her to be a professor in my law school, which I didn't go to. I have a feeling she could make talking about motor oil interesting, but, well, you know what? Motor oil is interesting, Tom. Strait of Hormuz, etc. Okay, we also have a first timer with Leah. Liz is joining any podcast. This is her first ever podcast. And that's a landmark in somebody's life. And I think people put that in their diaries and in their biographies and in their books. So if you're going to start anywhere, though, I think it's best to start with a highly disciplined production situation like we have here at the Emerging Litigation Podcast studios. All right, well, let's get to it. Here is my conversation with Liz Heddleston and Leah Stiegler of Woods Rogers. I hope you enjoy it. Leah and Liz, thanks for joining me on the Emerging Litigation Podcast.
Thanks for having us. Great to be here.
Liz, could you say that with a little more enthusiasm? I'm kidding. That's all right. No. You have as much as I do right now.
It's great to be here.
Oh, easy. This is like a monster truck rally. So to set the stage, I have introduced you already, and I've told listeners generally what we're talking about. We're talking about HIPAA and privacy and things like that. But in September of 2025, the OCR announced a settlement with Cadia Healthcare facilities. They investigated allegations that they were posting patient success stories, which is something that a lot of companies do. Law firms do it. Publishers do it. This is what we did that was really great. You want to know about it. So they put these online, and they I guess inadvertently published some details that disclose protected health information. So talk about what Cadia did wrong and what the OCR is doing.
Absolutely. They did a few things wrong here, and that's why we ended up with this settlement amount. Cadia, as a starting point, they're a provider of rehabilitation, skilled nursing, long-term care services. So they're a healthcare entity. And because they're a healthcare entity, they're a covered entity and they must comply with HIPAA. But, they're a business too. And like any business, they're doing their social media marketing and all of that. So in this case, like you said, Tom, they were posting these patient success stories. And from what we can gather from the, information OCR has put out there, these social media posts included the patient's name, some information about their conditions, their treatment and recovery. I imagine that they were very positive and inspiring, but at the end of the day, what OCR is saying is they did this without complying with HIPAA. So what they did is they didn't have these patients sign valid HIPAA authorizations that basically say, we consent to you, Cadia, my information about my health in an online format. So that was kind of mistake number one. Is, well, first, that they posted this information and didn't really. We don't know exactly what was happening, whether they realized it was PHI or not, but they posted it, and they didn't have these valid HIPAA authorizations, which they have to be in writing, and they have to have all these elements required by HIPAA. So we don't know all of the facts. It's possible that the patients at the time were very well aware of the social media campaign, that many of them were cool with it. They might have verbally consented. Again, we don't have all the details, but in situations like this, you might even have a provider have them sign like a 2-sentence, yes, you can post my image online. But unfortunately, something like that doesn't comply with HIPAA. And I think Leah wants to chime in. Yeah.
No, I think that point, Liz, about, probably a lot of the patients were generally okay with it in the sense that maybe for a while there was some low risk there. When working with assisted living or nursing facilities, oftentimes, the companies refer to the individuals living there as residents, not patients. And so there's also that, I don't know if it's just using that term in a way too, that you don't necessarily think of it as, we might need to, from a HIPAA perspective, we can't market it the same way. And I'd say even my sister-in-law, her grandmother was at a facility, and I remember going out to dinner with her, and she was like, oh, they're doing crafts today, because they were doing these Instagram and TikTok videos of the residents. And sometimes it wasn't like the residents were sharing health information. They were just videos of the residents maybe dancing to something or having a chess tournament. So from your perspective, Liz, is it even just, would HIPAA be triggered even just showcasing someone living there as a resident/patient? Or does it also have to be content that shares health information?
Yeah, so it's a fact-specific analysis, but basically, simply identifying someone as a patient or a resident of a healthcare entity, a rehab facility, a skilled nursing facility, that alone is PHI. The definition of PHI under HIPAA is very broad, and simply demographic information alone, that combined with the fact that they're a patient, that is enough to be considered PHI under HIPAA. So you could be posting, residents playing chess at a rehab facility, but the post is probably, it includes the name of the rehab facility. So there's this assumption, yes, they are patients or residents there. And even though it's focusing on the social aspects, that's still, from my perspective and from what I've seen into how HHS approaches that, that's still considered PHI. And you have to, you can disclose it. You have to get the patients to sign, a written authorization saying it's okay. And again, it's not just any little, 2-sentence consent form. It's got to be the HIPAA compliant authorization that has the elements that HIPAA requires.
Yeah. You mentioned they were filming them also dancing. What if you're an embarrassingly bad dancer? Is that covered? Is that something you don't want to disclose?
That's probably how the patient complaint got started, actually.
I bet that is it.
They were learning the square dance. And actually, it's funny. I could speak to this as not just as a lawyer speaking on this topic, but as a victim of the PHI disclosure, not because of my poor dancing, but actually.
Oh, I thought that's where you were going.
No, when I was growing up, my orthodontist used to have everyone's photos, with their smile, the before and after pictures, pictured up on the wall. And I came in one day and I was like, oh, what happened to my photo? I was like, actually, my ego was hit by the fact that they took down my before and after photo. For HIPAA reasons, we're not allowed to post it anymore, right? So even Liz, is it enough? I mean, in that scenario, right? I was kind of consenting verbally by way of saying, yeah, you can take my picture. I mean, would that not be enough?
It's not enough. Yeah. It's enough for certain other types of disclosures under HIPAA. Like, if you're getting treated and you bring, another family member to treatment and they're in the room, there's you can verbally say, yes, you can share my PHI with that family member. But when it comes to publicly sharing PHI, whether it's in the wall of an orthodontic office or obviously online, verbal consent is just not enough. And I think OCR was very clear with that. And to the point of the bad dancing and Leah's point here, and a lot of times in this scenario, probably a lot of the patients were generally okay with it. But then you got the one who wasn't, and they complained to HHS OCR. Every patient has a right to do that. It is very easy. You go online, you fill out a complaint form, and HHS OCR has an obligation to investigate that. And so that's how we see a lot of the enforcement coming from. And in these kinds of situations, it's that one patient who's not cool with it. And then you've got HHS looking over your shoulder, and then they're doing the investigation. And in this case, they found out it wasn't just this one-off social media success story. It was 150 times, right? So that was another thing that went wrong here. It wasn't a one-off mistake that they kind of corrected. It was a pattern, and HHS OCR is big on patterns. So it happened, I think it was 150 times. So they were doing it a lot. And then the other kind of problem of what went wrong here is once they discovered what happened, and I'm putting all this together kind of from the settlement, and they had like a resolution agreement that's online. But once they found out what happened, so they did the immediate corrective action, which is they took the post down. So that's good, right? You've done some damage control, but they didn't follow the HIPAA breach notification rule. So they didn't take that next step that says, okay, we had an impermissible disclosure of PHI. We shared all this PHI online without patient consent, as required by HIPAA. So they did not treat it as a breach under the HIPAA breach notification rule and issue the letters that you're required to do in those kind of situations. So there were, quite a few things here I think that went wrong. And then the other issue cited in kind of the resolution agreement is it basically implied that they didn't have compliant HIPAA policies. So that's kind of how some of this probably came about. And, they cited the need for some additional training going forward.
Well, and I think that's really important because in a setting like that, it's very common for the clinical employees, anyone who's maybe a med tech, LPC, nurse, the clinical employees to have HIPAA compliance training. But you don't always think about giving that kind of training to the back office employees, maybe your HR team, or in this case, your marketing team. And so there was probably a gap to some degree in from an informational standpoint. The marketing team was, doing a great job marketing these stories, probably brought in a lot of residents doing what they're supposed to be doing, just without the HIPAA compliant process.
Absolutely. Yeah. And I think what we see in pretty much, all of the HIPAA settlements is organizations really have to take an enterprise-wide approach now with HIPAA compliance because of the way PHI flows through organizations. It's really just not confined to clinical and frontline, like Leah mentions. It's PHI is used often for marketing purposes. So we have to be broad in how we think about HIPAA compliance and not have a siloed approach, but really be holistic to kind of prevent situations like this from happening.
So I guess when you say it needs to be looked at in a broad way, so it's beyond employees, because I know we all aspire to be social media influencers. Well, Leah may be already, but that these are third parties. These are contractors. They're not employees. So does anything change?
Yeah, good question. So yeah, my impression from the Cadia settlement was I think the internal marketing team, although I'm not sure they got into detail, but increasingly, healthcare organizations are outsourcing marketing or relying on third-party vendors for marketing because they have, more specialized expertise. So when you do that, when you share PHI with a vendor for a marketing type purpose, the covered entity, the healthcare entity, is still kind of legally on the hook for those disclosures and how their vendor uses PHI for marketing purposes. So yeah, it adds another layer sort of to the HIPAA compliance analysis.
Yeah. One thing for companies to keep in mind is when they're healthcare companies, especially when they're working with outside vendors, is to make sure that their contracts with those third parties address stuff like this, including maybe an indemnification clause, but even beyond just HIPAA compliance, requiring HIPAA compliance with your third-party vendors, just in general, if those marketing vendors come in and they're taking videos or photos of even employees, then there also are other consents that you need as well. And so getting we live in the NIL world, not just in terms of athletes, but even with employees, obviously with patients, you can't just necessarily use someone's name, image, and likeness without proper disclosures and consents.
Yeah, absolutely. And from a HIPAA standpoint, if you hire an outside vendor to do marketing on behalf of you, the healthcare entity, they might legally be a business associate. So they're then going to have their own HIPAA compliance obligations, and you have to have a business associate agreement in place. And, I'm seeing with some of my clients, you have a lot of people kind of in the ecosystem now in marketing and doing it across industries. And some folks they're going to hold themselves out as they're not going to understand the regulatory side of the healthcare industry, that what you can do in another context, for a restaurant or some other kind of business, you can't do that in the healthcare context without, the proper patient consents. So what that comes back to is the healthcare entity is really responsible for vetting its vendors and for the legal analysis around, are they a business associate? If so, we need to make sure the PHI is shared in a compliant manner. You can't just rely on the representations of the vendors. I had a client recently come to me and was like, we have this vendor that wants to help us manage all of our online reviews, and they want us to respond this way. And I was like, no. You can't do it that way. Like, though it was just not in line with the way that what HHS and HIPAA requires in responding to online reviews.
That's not in line with a lot of things, I think.
Yeah, what would that have even looked like? It's like a physical therapy practice or a medical practice, and someone writes an online review and was like, my knee was never the same, and then the third-party vendor comments back. It was like, it wasn't our fault. It was because you didn't comply with your PT, on a regular.
That kind of thing has happened. There have been HIPAA settlements where medical practices have shared PHI in their responses to online reviews, and they've had to pay thousands of dollars. And people even acknowledging in the review that individual was a patient without kind of responding substantively can be an issue. So there's just a lot of hot water areas. There's a lot you can do with marketing. That's okay. But you have to vet it under the HIPAA analysis, and you really can't rely on the representations of the vendors, especially the ones who are kind of newer and less sophisticated.
Wow. Yeah. That could just go so many ways. Your knee wasn't that great to begin with.
Yeah, so. Right. Maybe if you lose weight, you would be.
Yeah, good God. Yeah, maybe you should dance more. No, I guess I went through this a little bit. I'll make this relevant, trust me. So I'm a grandfather now. My daughter had a baby on Christmas. We're very happy. So naturally, I take pictures of the baby and I put them up on Facebook. My daughter immediately said, very nicely, would you mind taking that down? I'm like, that was her version of a HIPAA violation, I think, because, I don't want my baby's picture ending up on like whatever advertising or whatever because of her name, image, and likeness. But I thought, well, if I don't put her name on there, haven't I de-identified her? Plus, she's a baby, and she's going to look different. But
they all look kind of the same.
She doesn't, Leah. She is absolutely gorgeous. Oh my God. All right. I'll send you a picture and you just don't share it. But anyway, so I thought I anonymized it or de-identified it. So how does that work? If you just remove someone's name, does that get you in compliance with HIPAA?
Yeah, no, it does not.
That's my favorite answer. Yeah, no.
No, it doesn't. So yeah, in kind of your scenario, assuming it was in a healthcare context, the full-faced photo of an individual, even without the name, that can be PHI. So yeah, there's kind of a misconception that if it doesn't contain the name, it's not individually identifiable, it's not PHI. But it's actually really the definition of PHI is very broad. So if you can reasonably identify that individual, even indirectly, that can be considered PHI. And in fact, to ensure that it's not PHI, you have this sort of safe harbor under HIPAA, the de-identification standard. Do you want me to get into that yet?
Yes, please.
Under the de-identification standard, you are kind of in the safe zone. So you can share this data because it's no longer considered PHI. But it's pretty hard to meet the de-identification standard. There's two ways to meet it. The first safe harbor is removing 18 different specific identifiers that are identified in the regs. These are things like name, full face photo, geographic identifiers like, the zip code, things like that. So if you strip the data or if your data doesn't contain any of those elements, then it's considered de-identified and you're safe. And there's 18 different elements you have to ensure that you've stripped out. So that's what, yeah, go ahead.
What if my orthodontist had just, instead of taking a picture of my face, just the before and after of my mouth? Would that probably have worked?
That's like kind of getting in the gray zone. So yeah, so if it is, just a partial of your face and there's not anything on like a face tattoo or something.
Let's be clear for these audio listeners that I do not have a face tattoo.
But if you have a face tattoo, and they know you're in so-and-so town, you can identify someone just by showing their mouth. What I'm getting at is it's a fact-specific analysis. So you might be in a safer zone if it's not a full face photo and it doesn't say anything more specific than just this is a partial image of the before and after of the mouth. I'm
sorry.
My face tattoo was sort of there can be exceptions, if there's something very distinguishing about that photo. Nowadays it's
a known smile, like Mike Tyson. Everyone knows Mike Tyson's smile, right? So if his orthodontist just had his mouth, that'd probably be a HIPAA breach.
Yeah, AI could identify that, I'm sure.
Wait, no, he's a celebrity. Can we still? No, never mind. But if you're going to get a face tattoo, Leah, what would it be?
That's a really good question.
You don't have to answer. That would be private.
That would be private. I don't know. It's probably some kind of cool like snake around the side of my face.
Sure.
Only on one side. So if I had to stay professional, I could always just look to my right or something.
That's right. Yeah, that's a good idea. Yeah. Or you could just put the Emerging Litigation Podcast logo. I'll pay for that.
That's interesting.
Never mind. What were you going to say?
I was going to say an interesting HIPAA breach situation that Liz helped me out with. So Liz and I work together a lot because, as you can imagine, oftentimes at healthcare places, it's employees who are breaching HIPAA in some manner. But we had an interesting one where an employee, the employee's husband, who they were going through a separation, she ended up accessing his medical information through like their charts because she was an employee there. And so, even if, and there was no evidence that information was ever like used in any way, right? So that the knowledge of his health information was ever used in any way, but it was still, Liz, right? It was still a HIPAA breach or potentially a HIPAA breach in the sense. So the person accessing it doesn't have to actually use it or market off of it or monetize the information, and obviously in the Cadia Healthcare situation, they were using it for marketing purposes. But even if it's just access alone, right, that triggers HIPAA.
Yeah, I mean, that triggers the definition of a breach under HIPAA. And that's the classic employee snooping situation, which I'm sure you deal with on the HR side all the time.
Sure.
And it's a classic scenario under HIPAA where, you have an individual who has access to the EHR, but they can only look at charts for purposes within their job. They can't, snoop into their, separating husband's EHR. So I forget what your original question was, but yes, access, that kind of inappropriate, impermissible access triggers a definition of a breach. There is some sort of legal analysis you have to go through sometimes to determine if you have notification obligations, but it is a presumed breach unless you meet, this low probability of compromise standard. But in a situation like that, it's very likely an employee who might use that in an inappropriate manner. So you kind of have to presume it's a breach unless you have these facts that show, hey, there's really a low probability of compromise here.
Okay. And then we did talk about, we had it queued up to talk about, and I think you addressed it though, working with vendors and influencers as opposed to in-house folks. But I think you made the point that in the contracts with vendors and things, you have to be aware of HIPAA compliance and comply with those rules. Was there anything else to say about that, or feel like you covered it?
I had a thought based on your baby photo sharing example that I wanted to link back to around social media influencers.
Do it.
So patients have a right to share their own health information all over the internet if they want to. You can post everything you want about your cancer journey or on Facebook or whatever. Where you run into an issue with a healthcare entity is, so say the hospital media team wants to reshare the local social media influencers' patient success story. That resharing can be without the written consent of that patient. That could be a HIPAA violation. So it's kind of a new frontier. You have to be careful. So the social media influencer patient, they put it out there publicly. That doesn't mean the healthcare entity can then reshare that post on their own platform. That's taking it into HIPAA territory.
That's so wild, because you would think that, if my mom shared a patient success story of herself, right, I could reshare it, no problem, but the actual entity itself couldn't, without potentially having to go through the HIPAA compliance requirements.
If the entity is sharing it as hey, this is our patient, and we're resharing their story, can you share a generic, like a celebrity is posting about their health issue or a cause, you're not holding them out as your patient. That's different, but it's just kind of, there's with social media influencing and just the digital ecosystem, I think there's a lot of ways you can run afoul of HIPAA if you're not careful and if you don't have your guard up. And that gets back to what we talked about earlier, is to not silo HIPAA compliance, but to really have the marketing folks, the business folks trained and just know when to raise the red flag, when to say, hey, we need to put a pause. We need to talk to our compliance team, our legal team. And I mean, that's kind of one of the big takeaways, I think, from all of this.
Right.
Basically, Tom's grandbaby can share her own experience about being birthed in a particular hospital, but Tom, you can't.
Yeah. I just
the hospital.
Yeah, I'm just not doing it anymore. Yeah. I really want to, though. Too bad. Okay, so I can send it to people individually. No, but the fix, Liz, to your point, if somebody sees that somebody else has shared their good story, it wouldn't seem to be a difficult fix to contact the person and get them to say it's okay to use it.
Absolutely. Practically, that's the practical workaround. You can 100% do it if you get their written authorization to do it. So you can do it, but you need to comply with HIPAA when you do that. And when I say you, the healthcare entity, the covered entity.
You didn't mean me personally.
But yeah, so it's, there's a lot of avenues for using PHI in marketing, but at the end of the day, HIPAA is about protecting privacy and giving patients a right over how it's used. So you really have to honor that. And that's why HIPAA has these strong consent or HIPAA written authorization rules. They really, it's like you really understand what PHI we're going to disclose, the reason we're going to disclose it, that you have the right to revoke your consent. You really have to jump through those hoops so that the patient is kind of informed, and it's not just a casual consent, because once it's online, it's going to be up there forever,
Yep.
So that's kind of what the heart of it is getting at with it.
Yeah. And I guess too, I don't know, because I was just talking to somebody else about digital evidence. So I'm wondering, does PHI also cover metadata? Excuse me, did I say PHI? No, with these HIPAA, did I say this right? Let me ask the question again. If there's metadata on a photo that has identifying information, but it's not obvious to most people, does that ever come up? Does the metadata disclose?
Metadata could if it's disclosed and some third party can access it, it absolutely can be considered PHI if it provides additional information around the patient so absolutely. There's been a lot around like how a patient's IP address when they visit a healthcare entity's website,
Right.
that alone can identify an individual. So that can be considered PHI because there's some litigation around this right now, but it's a pretty broad definition. So you do have to be careful.
Yeah. Okay.
One thing I think is important to note is that HIPAA does not cover employee medical information, assuming the employee is not a patient. So this is constantly confused in my world, in the employment world, where, an employee will submit a request for a reasonable accommodation under the Americans with Disabilities Act, or the employee will request leave for a medical reason under Family Medical Leave Act. Frequently, managers or even very experienced HR professionals will say, well, I can't discuss this with other executives or something because of HIPAA. No, HIPAA applies to a healthcare entity's protection of health related information to patients. It's actually the Americans with Disabilities Act and maybe some other even state laws that cover protection of employee medical information. But it's commonly confused.
Yeah, I can see why. Well, it seems like OCR is typically what we know it for is focusing on data breaches and ransomware and things like that. With increasing use of social media and influencers and third-party marketers, the first question is, do you expect to see more of this, and then if so, what do you think healthcare leaders should be doing right now?
Yeah, so I do expect to see more of this. I think that HHS is attuned to I think ransomware and those sorts of data breaches, they're going to continue to be kind of the bread and butter of the enforcement activity we see with HHS OCR. But I think that HHS is going to continue to look at these sort of privacy breaches relating to social media and marketing and things like that more. So I think, it's sort of building on a couple years ago when they were looking at providers responding to online reviews and sharing PHI that way. Now they're looking at kind of patient success stories and social media marketing. So I think this is sort of an example and a deterrent, but I think that they will continue to investigate that. I do have to caveat that with, there have been significant thinning of the federal agencies, including HHS OCR. So some of the manpower, could impact just the volume of activity. But even since those cuts, I'm still seeing very active HIPAA enforcement. Last week there were 4 settlements announced. They were all kind of bread and butter ransomware incidents. They were not high dollar, or they weren't high profile Change Healthcare type breaches. They were run of the mill ransomware impacting, from 7,000 patients to maybe 100,000 patients. And they all, they were settled with fairly significant financial settlements, 200, 300,000. So, HHS is not slowing down. We are going to continue to see a lot in the realm of ransomware and data breaches. But I think that, these more kind of operational type disclosures, they're going to continue to pay attention to that. And especially, I'm waiting for the first one that's very AI oriented, because I'm sure that's coming. I think they are watching these kind of newer frontiers of how PHI kind of gets used in the digital ecosystem. And I do think we're going to continue, resources permitting to see enforcement action in those areas.
I think what you just touched on, I think the new frontier on top of the operational one that we're looking at with Cadia is a practitioner potentially putting in protected health information into ChatGPT, right? To have ChatGPT write the counseling notes or their supervision notes or whatever it may be, and kind of going after it in that sense. You use ChatGPT and you think, oh, the ChatGPT world, no one's ever going to know that there's billions of people using it every day. No one's going to know that I put this in here. But it's going to take one person finding out or one patient finding out and for us to see an enforcement action. But even outside of OCR enforcement actions, I don't think HIPAA has a private right of action for individuals, but there are state law claims that people will try to bring in terms of privacy breaches and confidentiality breaches or the name, image, and likeness issues as well. So that's another thing to be mindful of.
Yeah, ChatGPT, putting confidential information into it. It also comes up in attorney-client privilege and work product issues. There was just a decision about that. So, I mean, I use Copilot a lot, and the engine for Copilot on Microsoft is ChatGPT. Microsoft invests heavily in OpenAI, but it always tells you, don't put anything confidential in here. Of course, everybody listens to what they tell you on the web. So it's tricky. For the sake of, is there anything else before I go on? Is there anything else you wanted to add, Liz or Leah, on the employment side? I think we covered everything really well.
For sure.
Okay.
No, I mean, I'd say get those consents because we love to see the resident dancing videos. That makes our day. So it's not that hard to pay a lawyer for an hour to get a proper consent form so that you can still showcase some really fun activities.
Yeah. And if you're still in independent living, I suggest private dance lessons just because that's what's coming, when you do a hoedown. What is that called? Barn dancing? I don't know what phrase.
Blinded.
Let's see. I'm going to handle the key takeaways. So do you want to paraphrase those Liz, this is your main thing. And then, of course, Leah, you could add a fourth on employment if you like. But do you want to take a stab at that? I don't want to read them. I can introduce it. So Liz, what should people generally take away from this podcast? And then Leah will give you a shot too.
Yeah. So I think some big takeaways are, even if you have good intentions and you're putting out these patient success stories and they're positive and, the patients or the residents seem okay with it, that can still create HIPAA risk, right? You're still putting PHI out there, and you've got to make sure you have your HIPAA compliant written authorization in place. So your good intentions, your benevolence, that's not going to be a defense. And I think paired with that is you really have to make sure you have an enterprise-wide approach to HIPAA compliance, because PHI is really, it's not limited to the clinical side. It's flowing to the marketing teams. It's flowing to the business teams. So you really have to make sure you have the training and the policies in place so that they have the awareness to raise the red flag before putting up those positive stories without the HIPAA written authorization. So that's a big one. Digital marketing is going to kind of expand your kind of risk areas because it's a little bit of a new frontier. There's vendors out there who don't really understand HIPAA. So you have to be aware of the risks when you're working with vendors and using PHI with digital marketing. So there are some new HIPAA risks you need to be aware of. And I think I already touched on it, but HHS OCR is big on HIPAA compliance is enterprise-wide, and pretty much every settlement I see, they're finding kind of systemic non-compliance with HIPAA. So just an overly narrow approach to HIPAA and not taking that holistic approach. And frankly, the way we share PHI and the way it flows in organizations, it's not paper anymore. That's decades ago. So it's really complex. And it's harder for organizations to understand how it's flowing even within their own organization and then to vendors. So you have to really kind of keep up with that, map how the PHI is flowing and how it's flowing outside of your organization and for what reasons and to whom, and just get a handle on that. And that's really going to help you with your HIPAA compliance.
I'll just add from the employment perspective, train. Don't just train the clinical personnel, train the marketing, admin, your in-house lawyers, train them all. Because another area you can litigation that you can face is in the negligent hiring or negligent retention area for if you've got an employee who's, breached HIPAA or disclosed improper health information and you're not properly taking an action as a company to discipline them or ensure no further harm, and that employee continues to do it, you're running afoul in the state common law area as well. So just be mindful of that.
Okay. Leah, while we were doing this, my producer contacted your orthodontist and tell me if this is true or not, that you went back in and you were taping up pictures of your face in the office. Did that happen?
At a young age, I knew I was a narcissist, because I had to have my face up there.
You must have a show business thing going on. Look at you, you're podcasting and all this. You have your own microphone. I don't know. Maybe you should have been, do you ever do community theater or stand up or,
No,
that's next.
I was in one play. I was in a Shakespeare play and I think I was like Ophelia or something. And I talked to try to speak in Shakespeare speak, and every sentence sounded like a question. And so I remember like the director being like, so not everything is a question, and I was like, but I don't even know what I'm saying. So half the time my sentence is just like where they go down that road, I don't know.
I don't know. I can't read them. So anyway, Leah and Liz, thank you very much for doing this. I appreciate it. It's good information today.
Awesome. Thanks for having us.
Thanks so much.
Liz, you survived your first podcast. You okay?
I feel good.
Yeah. You're going to do more now.
With Leah and Tom was a blast.
Good.
Okay.
You kicked butt.
I'll use that as a testimonial without your permission.
Tom and I talk about mainly irrelevant things.
Yes.
So I'm glad you got in all the substance, Liz. That's very important.
I'm here for the substance, but I enjoy all of it.
Yeah, we go off track and it's mostly my fault, but it's really funny how Leah just follows right along with it. Most lawyers are like, okay, yeah. And so what the law really said. Yeah. One made a mistake of asking me about the pictures on my wall. Oops, sorry. He asked me about the pictures on my wall and they're boxing pictures. So once he asked me, I was like 15 minutes. I'm like, oh God, I'm still talking about Jack Dempsey. I moved on to Joe Frazier, who I loved, and how I really don't care for MMA boxing and whatever. Okay.
That's the thing. But
you guys get back to work.
Awesome.
And thank you so much.
Yeah, anytime.
That brings us to the end of this episode of the Emerging Litigation Podcast. Once again, I'm your host, Tom Hagy. If you like what you hear, please give us a rating. That always helps. And also follow us on, you can follow us on any major podcast platform, Apple, Spotify, all the rest. You can also check us out on YouTube for the video version and some clips, and as well as Instagram and quite a few on LinkedIn as well. If you want to participate, give me a shout. My contact information is in the show notes. Thanks for listening.